Good evening, ladies and gentlemen, and a warm welcome to this evening's discussion. It's a pleasure and a privilege to welcome all of you to this discussion on the Rule of Law report, the second one of its kind released in July this year by the European Commission. This is, as you can imagine, an important and a very timely event. And before I introduce my three distinguished guests for this evening, let me just say a word about myself so you know who is moderating this evening. My name is Shalini Randeria. I am the new rector and president of the Central European University in Vienna and in Budapest. And we're probably one of the few universities in Europe which have not only produced a lot of academic scholarship on the subject of the rule of law, but we've also experienced the abuse of rule of law at an institutional level by, unfortunately, a member state of the EU whose legal, formally legitimate legal steps led to a situation of such legal insecurity that the university was forced to move all of its American accredited programs to the safety of Vienna from Budapest. So this is, of course, a topic which really is at the heart of the current problems facing my university. And I'm really glad that the rule of law is such a major topic for discussion in Brussels and in all the capitals in Europe at the moment, because I think the report is being circulated, read widely, commented, and is the subject of invited discussions all over the continent. I think one of the things which the dilemmas faced by my university made clear is a distinction between rule by law and rule of law. And I think one of the problems, paradoxically, that we've been facing in the last years, not only in Europe, but I think worldwide, is, and the paradox is that with the successful spread of formal democracy, there's been a hollowing out of substantive democracy. And not only has there been an erosion of substantive democracy, but it's actually being hollowed out by formally democratic means. And that, I think, makes it such a difficult problem to combat the kinds of attacks we are seeing against judicial independence, media freedom, separation of powers, or the right to assembly, which are all being weakened slowly, systematically, in many member states of the Union. The rule of law, as I think all of us would agree, is not only a really integral part of the democratic identity of the European Union and its member states, but it's also essential for the functioning of the Union, and especially for the trust which citizens and businesses should repose in public institutions. Respect for the rule of law entails not only full compliance with European Union law, but also acceptance of the principle of the primacy of EU law, which is also being currently challenged in some parts of the Union. So I think the EU can only allow the rule of law to be evaded or sidestepped or subverted at its own peril. The report that we are about to discuss is the Rule of Law report published, as I said, in 2020 to provide an assessment of the developments in each of the 27 member states with respect to justice systems, anti-corruption frameworks, media freedom, media pluralism, and other institutional checks and balances. This year's report also shows, as we will hear from you, some of the steps which have been taken already to address some of the challenges in this area, though of course shortcomings remain, and these will need to be addressed soon. The publication, therefore, as I said, marks the start of a cycle of dialogue and of monitoring. The event today takes place in the context of a number of current but also potential constitutional crises, which we will need to discuss with our panel this evening. The report is therefore crucial and timely. With that, let me just introduce my three panelists. A very, very warm welcome to you, Commissioner. Didier Reynders is the European Commissioner for Justice since 2019. Prior to that, he was a member of the Belgian Parliament, actually since 1992, a long innings. As Commissioner for Justice, his responsibilities include ensuring that the rule of law is upheld, of course, including the European rule of law mechanism, And the European Commission, as you know, is responsible not only for proposing legislation, enforcing EU laws, and directing the Union's administrative operations. To my left, Professor Christoph Grabenwarter. He is a renowned Austrian legal scholar. He serves since 2005 as the president of the Austrian Constitutional Court. He has been the Austrian member of the Venice Commission of the Council of Europe since 2006. He is also professor of public law, business law, and public international law at the Vienna University of Economics and Business Administration. He is widely published in the fields of international business law, public international law, with, of course, a special focus on human rights, which is pertinent to our discussion today as well. His commentary on the European Convention on Human Rights, written in 2014, is seen as a seminal commentary. Last but not least, let me turn to Dr. Maria Berger. She's a former justice minister of Austria and a former judge at the European Court of Justice, where she served for 10 years from 2009 to 2019. Dr. Berger was elected a member of the European Parliament herself in 1996, where she served until 2009. And it was a period interrupted by her tenure in between from 2007 to 2008 as the Justice Minister of Austria. She's also served in the European Parliament's Committee on Legal Affairs and is also honorary professor at the Department of European International and Comparative Law at the University of Vienna. So thank you very much for following our invitation for this evening. And let me just begin. We're going to discuss in 3 blocks of questions, but we're also going to leave enough time for our audience to send us questions. So please feel free to start with any questions you may already have in mind or those which follow from the discussion. Please put them into the chat function. I will be given your questions in about half an hour to 40 minutes time, so you have enough time to think through your questions, and then we'll leave enough time for a discussion of your questions. So let me begin with talking about the report as one tool in a toolbox which the EU has for strengthening the rule of law, the others being mechanisms like conditionality, infringement proceedings, 2 of them are ongoing, also dialogues, different kinds of monitoring mechanisms, which can be both in the form of naming and shaming, with showing a lot of the violations, but they can also showcase extremely positive developments in many countries, which the report also shows. So the question here for me would be, do you think that toolbox is adequate? What kind of a tool is the report itself? And do you think we need to think about other modalities to enforce the rule of law better?
No, first of all, it's all the time possible to think about new tools, and it was the case with the new Commission in the actual mandate, because we have put into place new instruments. I was just to say that when you look to the toolbox, like you said, of course it's possible first to open a dialogue with the member states to see how it's possible to improve the rule of law in different ways. That's a normal way to discuss and to see with exchange of views it's possible to have an improvement. Of course, in the toolbox we have also the normal process in a rule of law system. If we have a real conflict with the member states about the EU law and the implementation of some part of the EU law, it's possible to go to the Court of Justice and, of course, to introduce infringement proceedings and so to let, at the end, the last word to the Court of Justice, because it's possible to disagree with the Commission, of course, but at the end of the process, if we have a ruling from the ECJ, you need to apply. It's a binding decision. Then we had in the treaties, and we have the Article 7. So it's a quite strange procedure. You know that we have used that at the Commission level about Poland and from the Parliament about Hungary. And so we have discussions in the Council to see if there is a risk of a breach of the rule of law. And then if there is a risk, to impose some sanctions. But the majority rules are so difficult to reach that it's a very long debate, and we continue to discuss on this at the Council level. And so during this Commission, we have tried to add 2 new instruments. The first one was the rule of law report, but I will go back to that. But the last one, the 1st of January this year, was the conditionality between the funding of the different policies and the rule of law. So how it's possible to be sure that we have a correct implementation of the rule of law in the member states without any risk to have a misuse of other kind of possibilities to use in different ways the European budget and the funding coming from the European Union. So it's a new tool because there it will be possible for the Commission to ask to the Council to stop or to suspend the funding of different policies due to a breach of the rule of law. So it's a real important instrument because, of course, there we have a possibility to act with a real pressure on the funding of different policies. But the other one instrument that we have introduced during this mandate is the rule of law report. So it's true that we have published 2 editions already. So it's a cycle. Every year we'll do that. And that is more a preventive tool. If we compare with the infringement proceedings or the conditionality, here we are more organizing a real dialogue with the member states every year with a presentation of the positive and the negative developments about the rule of law in all the member states and in the 4 chapters that you have described. And of course there it's possible to try to avoid any emergence of a breach to the rule of law or a deepening of an existing breach. And if I'm looking to the rule of law report, we try to organize the process with a very good participation of the member states. We have a good dialogue with all. I must say that for the 2 first editions, it was possible to work with the member states without too many problems. We have a participation of many stakeholders. To give an idea, we have organized 400 country visits, of course by video during the pandemic, but to discuss with different kind of stakeholders at the European level, at the national level. And we receive many contributions, more than 200 written contributions. So it's very clear that we are working in an open kind of debate about all the different elements. But at the end, the rule of law report is an assessment of the Commission. It's very clear. It's our assessment about the situation. And then we engage a dialogue in the European institutions. So in the European Parliament, of course, I have had debates in the plenary, in the Libe committee on the rule of law report. We engage also in the Council, with the Geneva Council. And that is very interesting because we have not only a general debate, but also a peer review about 5 member states. To give an example, it will be the situation of Austria next year during the French presidency. Austria will be one of the 5 member states concerned by the peer review. And then we try also to do the same at the national level. And that is maybe the most important element. I was also today in the Austrian parliament to discuss with the parliament members from the majority and the opposition about the rule of law report. And we try to organize, like today, many debates at the national level. Because the main goal, in fact, is to install a culture of the rule of law in all the member states. And I've been saying that it's, of course, a very important tool and with an impressive success. If I'm looking back, after the first report, we have received many proposals for reforms, action plan, and improvement of the rule of law situation in quite all the member states. And of course, now we need to verify in the follow-up if it's true that we will have some kind of reform. But of course, we have remarks, concerns, and observation about all the member states, but in some cases, we have more systemic issues. And it's not by coincidence that we have, I said, Article 7 procedure about Hungary and Poland. And we have maybe more concern about those 2 countries also in the rule of law report. And so it's for those countries maybe very important to use other tools, like I've mentioned, infringement proceedings, and maybe some discussions about the funding of different policies. We will see, maybe for other member states again. And so I will describe the rule of law report as a very useful preventive tool, a useful tool to install a culture of the rule of law, not only in the European institutions, but on the ground in the different member states, to engage with the member state. But of course, to do that, we need to have a very good collaboration. And we have had a good collaboration for the preparation of the report, not all the time to organize reforms and to improve the situation, but in a very large part of the member state is the reality. So that's the description of the tools that we have. Is it possible to think about other tools? Of course. But I'm sure that we have now a very good toolbox. If there is a real common vision on the rule of law and a common vision about the way to improve the situation in the Commission, in the Parliament, in the Court of Justice, I hope more and more in the Council, It's maybe the most difficult discussion between the member states, but also at the national level. And we will speak about that maybe later, but in the different member states and here in Austria, because I was for such a kind of discussion, we have seen that with the rule of law report, it's possible to engage about concrete reforms and sometimes about very sensitive reforms.
So thank you very much. I'm going to return to you, Commissioner, in a moment after we've had our first round with a couple of specific questions. But I'd like to first go to you, Dr. Berger, both in your experience as a member of the European Parliament, which was, and also as a member of its Committee on Legal Affairs, but also, of course, as a minister here. You've seen the evolution of this toolbox yourself. Would you agree with this assessment that the report itself could have a preventive effect? And do you think we would need, I mean, the other tool, of course, which has been introduced this year is also one with sharper teeth, should I say, the conditionality. Do you think these will be enough to be able to prevent some of the backsliding we are seeing, or do you think we need other more effective tools, and what could those be?
Okay, thank you very much. As you mentioned, I'm following European justice policies since many years, and when I started in the European Parliament, this was not at all an issue.
Exactly.
It was, of course, because of the competences of the European Union and its institutions. At this time, justice questions or how member states organize their judicial systems was not at all a question at the European level. And I remember also times when it was for the Commission to somehow promote dispute solution systems, these alternative dispute resolution systems, because the idea was that these traditional old-fashioned judicial systems in the member states, they don't live up with the necessities of an internal market. But really, then afterwards, I think the situation has become very much better. I remember the first scoreboard on the functioning of the judicial systems in the member states, and that already was a quite useful tool also to compare the systems. And now the new report with this broad approach, and I like this broad approach even though I'm a lawyer, but I think it's very important that you look also on the media situation, that you look on the fight against corruption, and not only to stick to a very limited legal or poor juridical notion of the rule of law, and all the democracy aspects, pluralism, and all this also comes into the picture. And I think this that really is a very, very useful tool. Of course, it's one of many tools, and I think that the Court of Justice could help a little bit to develop the notion of the rule of law, in particular when it comes to what is an independent judicial system, and also why European Union law has an impact on how member states organize their judicial system. And this is one of the main conflict areas with some of the member states who still hold the view that European institutions have nothing to say on how we organize. And the court was very clear in saying, of course, you are free how you organize your judicial system, which kind of courts you are having, and so on. But you have to obey to certain fundamental principles. And one of these principles is, of course, the independence of the judicial institutions. And I think this helped also to develop the infringement procedure, because in former times, the Commission didn't really dare to raise systemic questions when it came to an infringement procedure. It was a very punctual, so against Hungary, the Commission went against these early retirement rules for Hungarian judges and notaries. Yeah, that was not really the point, of course. The point was that the independence of the institution was in danger. I always called it a little bit the Al Capone method, because Al Capone was finally ended up in prison, not what he really has done, but it was tax evasion. But this punctual approach, yeah, I think with the help of the European Court of Justice could be widened, yeah, by opening it to systemic infringements. And what we see now coming from the Commission is that these infringement procedures are referring to general aspects like Article 2, the values, Article 19, and so on. No? So I think we have now a good combination of instruments, and even as a lawyer, I hate to say, yeah, but finally it seems to be the money, yeah, that makes the rules, yeah, and also what from the European Court of Justice perspective, what we have seen, yeah, also in member states like Poland, they did react in all the cases when there was a huge fine to pay. Then they finally, yeah, they didn't accept a judgment, but finally they did what the court asked. So maybe the conditionality mechanism and the new approach also of the Commission, that financial sanctions are asked, yeah, once a member state does not really react to a judgment, I think that could make an impact.
Thank you so much. Let me turn to you, Professor Grabenwarter. Do you see a change which is towards more compliance because of the toolbox, which has new tools? Or do you see that the kind of backsliding which we are seeing at the moment is actually going in the opposite direction?
Well, I think any assessment is quite difficult at this time, because we have to see a very positive development of awareness and activities on the side of the Commission. And for me, one of the major new developments was the 2014 instrument, which was put in place a year before the Poland crisis began, before the elections in Poland in 2015. So, bearing in mind that an instrument was there before the crisis started, of course, Hungary, the troubles in Hungary have started early on. So on the one hand, we have an increase in activities. On the other hand, we have new problems and new crises. And we cannot say whether the world would be better without the crisis and without the problems and without the instruments. Therefore, it's difficult to say with these new measures the world has become better. I think the world, or let me say the level of rule of law has become lower in some parts, but not because of any instruments taken on a European level, but despite of them. Mm-hmm. Now, the new tools, I think one has to differentiate. I would say one word that has been said repeatedly by Commissioner Reynders is dialogue. I think the approach of the Commission to have dialogue always behind every action is a very, very important approach. And I think this is sometimes not appreciated highly enough. It's always a culture of confrontation. And against this background, one has to look at the rule of law report. Nowadays, we need charts and we need the colors of the traffic light, and one is alarmed if it's red, and one is sitting back and leaning backwards and saying, well, it's green, so everything is fine. So when I looked in the 2021 report, the Constitutional Court is mentioned at one time, and it's it's saying the Constitution Court is reviewing measures related to the COVID-19 pandemic. So I'm happy about this, and we have a green light right next to it. So I was quite happy to see that. But if I look back to the last year, I would say there are a number of issues that were much more difficult, where I'm much more proud of our court, which are not mentioned there. Asylum cases, the majority of our cases are asylum cases. And to go on with high speed during the pandemic wasn't really a challenge for us, but I think we agree on this panel that asylum seekers are perhaps a group of people which, especially during the pandemic, need special care from the point of view of human rights protection. Therefore, I would really appreciate if one looks at every chart or traffic light from a point of view that it's not an assessment which is 100% sharp by a body which is not a judicial body. We have always to bear in mind we would not accept the Polish Ministry of Justice to evaluate the judges, and therefore I'm quite sure the Commission does not see the instrument as marking with 1 to 5 like in school, but it's a starting point for discussion, and one has to look at things and start a dialogue on it, and not to say, well, it's green, so don't touch me. No. It's just a description and a starting point for discussion, and if we go on with dialogue, I think we come to better results. An instrument which is mentioned in various documents of the European Commission is the rule of law checklist of the Venice Commission, and what I see so positive in every activity of the Commission, that it integrates various branches. It integrates the case law of the Court of Justice of the European Union, of the human rights of a case of Court of Human Rights in Strasbourg, but also the constitutional courts and other documents by NGOs, by international organizations. Last sentence, I think the quality of the Commission is this quality of integrating, and rule of law is a concept which comes from traditions from the member states. If you look at 3 languages and compare the notions rule of law, prééminence de droit, Rechtsstaat in German, you see that these concepts have in their background traditions of France, Belgium, United Kingdom still, even if United Kingdom is not a member state, the concept of rule of law has many sources also in the Anglo-Saxon legal history, and of course the German legal history, the legal history of the German-speaking world also supports this concept of rule of law. It's an abbreviation of a very deep concept rooted deeply in the legal traditions of the member states, and therefore this approach of the Commission is so valuable because it takes into account all these traditions.
So I'll come back to the concept and how capacious the concept is, and could it be made even more inclusive in a moment. But let me turn to one point which you made, Commissioner, and say, you mentioned the fact that there had been a lot of consultations, and among them consultations with various stakeholders, among them also civil society stakeholders. So I'm going to play devil's advocate for you here and say one of the critical points, critiques which has been mentioned by many of the civil society participants, especially journalists, journalist associations, human rights defenders, human rights organizations, is the fact that they felt that although they made a lot of submissions, and you said there were over 200 submissions, they were unclear about how transparent broadly, these submissions really were incorporated into the report, that it was unclear to them what is the status of the submissions that they are making. Are they being treated at par with the other submissions by the governments or not? How were they evaluated comparatively to one another, etc.? So could you say something about this unease which many of the civil society organizations have expressed, both about a methodology where they were not quite clear what it was for the report, and what the follow-up will be with civil society organizations in terms of the consultation?
Now, first of all, we have put into place, I'm sure, a very robust methodology, and we tried to do that, of course, with a consultation with the member states. So I've asked for the first report, and we continue to work with it, to all the member states to appoint a contact person and to discuss first the methodology and the way forward. And we have organized, as I said, a country visit, of course, due to the pandemic by video, but so we have had many contacts with, of course, the authorities, the government, the judicial authorities and so on, but also with many, many organizations at the European level, also associations of judges or journalists or NGOs, but at the national level. Is the reason why I mentioned 400 country visits. And then we have asked to receive many written contributions. So the input is very clear. We are working with many, of course, at different levels. The first one is to describe the standards on the different chapters of the rule of law. So, and there we are using the treaties, of course, and the Article 2 is the main issue, but there are other articles. Then the case law of the Court of Justice in Luxembourg, but the European Court of Human Rights in Strasbourg, and some evolutions in the Council of Europe, because we are working a lot with the Council of Europe, and certainly, as it was said also in the report, with the Venice Commission, and for the fight against corruption with the Greco, to take two examples. Of course, we will increase the follow-up in two ways. The first one, next year, for the first time, we will not only have conclusions on the member state, but recommendations. So it will be maybe clearer what we are saying about the different member states. But to be honest, if you read the first and the second edition, it's very evident to see what are the conclusions about the different member states. But it will be clearer. It was said by the President of the Commission in the State of the Union speech. We'll come now with concrete recommendations. And of course, with the civil society, it will be easier from this year to have a real follow-up with physical visit to the member state. Because, of course, I'm starting here in Vienna, but it was not so evident to do that with the virtual discussions. But I want to repeat, it must be very clear, because sometimes, also in the European Parliament, there are some other orientation. It's an assessment of the commissions. So we will find in the report all the sources described from different type of organizations, but at the end, the content, it's not a sum of all the different advice from the civil society and the authorities and so on. It's an assessment by the Commission, and we don't want to change it. Of course, on such a basis, we are very open to discuss with all the member states, the civil society, and we will do that. But so when I've seen some reactions to say, yes, but where are all remarks? No, at the end, we are publishing the assessment of the Commission. Only that, and of course it's a good basis, I'm sure, for many discussions. But it's true that about the follow-up that you mentioned, it will be clearer from the next edition with real recommendations about the different members. We are working on the way to
And the recommendations will be country-specific?
Will be country-specific, and we are working now to see how. But of course, if you read, we'll maybe discuss that about one member state, but if you read the conclusions and the summary of the country chapter, it's very clear that we have some concrete proposal to the member state. And it's the reason why I said we have received so many proposals for reforms in those elements. But it will be easier to organize a follow-up, to have very clear recommendation at the end of the different chapters. But again, we continue to work with all the civil society organizations, and I take the opportunity to say, if there are some intentions to send to us some contribution, it's fine. But at the end, we don't want to come with an addition of different advice coming from different parts of the society. We want to analyze that and to go out with the assessment of the Commission. And it's the reason why, with that, it's possible for the Commission to enter a real dialogue not only with the authorities, but also with not only with the government, but also with the parliament, opposition and majority, and with the civil society, to see how it's possible to improve the situation. And that's the main goal of a preventive tool like the rule of law report. Again, I repeat, we have other tools that are maybe less preventive, and it's when we have a real problem in the member state about the way to guarantee the rule of law or the protection of fundamental rights. And maybe one word about the remark concerning President the asylum seekers and the migration issue. Of course, we are first organizing the rule of law report on 4 chapters, and the first one is the independence of the justice system, because it's the mother of all the different orders, because if you don't have an independent justice system, you don't have any protection. But we don't have, it's true, in the report, an analysis about all the fundamental rights, about the Charter for Fundamental Rights and all those elements. There are other instruments to do that also, and we have discussions at the EU level on this, but for the moment the rule of law report is dedicated to 4 chapters, and I must say that it's a huge work for the services of the Commission to do that. And so we want to install such a culture before to go further. But it's true that we need to pay attention to the situation of in different other fields, like about the fundamental rights on democratic process. But you know that we have other kind of tools where we'll have also a report about the Charter of Fundamental Rights, and we will send that to the Parliament. But the rule of law report, it's first about the independence, quality and effectiveness of the justice system, fight against corruption, media pluralism, and then the other checks and balances. And it's the reason why we have seen some remarks about positive development in the court, in the Supreme Court, but maybe not, or in the Constitutional Court, that depends from one country to another one, but maybe not about the specific issues of migration.
But this is what I thought was interesting, because when Dr. Berger said she as a lawyer thinks it's quite a capacious understanding of rule of law, and then I was listening to you thinking, so the court has areas which you would consider to have been very great priority areas in the last year, and then they are not mentioned in the report. And I was thinking to myself, if one were to think about more systematic violations of the rule of law, then I think the areas which, but I'm not a lawyer, right? So I'm a sociologist, so I look at this report with a very different perspective. I thought there is nothing there on racial discrimination, which became a very big issue in the last year, as we saw transnationally, all across Europe as well, but also worldwide. Then, and that's missing completely in the report, the rights and violation, systematic violation of the rights of migrants, of refugees by so many European countries is something I would have expected in there and found missing.
It's not the goal of such a report. Again, the report is dedicated to the different elements that you have mentioned in your introduction, so the justice system, the fight against corruption, media pluralism, checks and balances. But of course, if you are speaking about the Charter of Fundamental Rights and speaking about many possible discriminations, it's another kind of instrument, and we are working with other tools to do that. Of course, it will be fine. I know there are some requests to do that, to have a description or in one report of all the possible situations related to the rule of law, the democratic process, and the fundamental rights. But again, it's not possible to do that in such a kind of report, but we are using other instruments. Again, we will come with a report on the Charter, and there it will be possible to take one situation and to describe it in all the member states. And then we are working on the European Democratic Action Plan, because we want also to discuss about the democratic processes, because you spoke about discriminations against some minorities. But you need also to be sure that we are living in a democratic system in all the member states. You know that we have 27 different electoral systems in Europe, but we are quite sure that they are democratic. And at the EU level, it's the same, because we have elections, but we need also to improve the participation of all the citizens, the most vulnerable groups, some minorities, to the democratic process. But we have other tools to do that. And again, the rule of law report is not to embrace all the possibilities that we have to show some discriminations and some violations of fundamental rights. It's first of all about the rule of law And the main issue, maybe, in the rule of law is the independent quality and effectiveness of the justice system to protect all those other rights. Because if you don't have an independent system for the justice, you don't have a capacity to protect the asylum seekers or to protect many minorities.
So thank you very much. Let me turn to the second block, maybe, of our discussion, which is to talk about the findings of the report, both as far as the situation of the rule of law in the European Union is concerned, but also as far as Austria is concerned, because this is part of the reason for the discussion here and part of the reason for your visit to Vienna. So may I start with you, Professor Grabenwarter? What would you like to comment on from an Austrian perspective on both the national and the state of the rule of law in the European Union?
Well, as I said, it's a good instrument as a starting point for discussion. I would not comment on any of the detailed results of the report, as I find it difficult to discuss publicly with an institution like the European Commission on what the Commission should have done better or has. So I'm not evaluating an evaluation of rule of law. As I said, it's a tool that should be used carefully, which is used carefully, as I have the impression, and I would underline what has been said. It's about the whole thing is to improve a rule of law in an overall perspective. The difficulty is, of course, if you start this issue, you have to look at single issues, but the quality has to be seen from a perspective on the whole thing. Many discussions on the rule of law have one problem, that you do a sort of cherry picking, and I have encountered that many times in country visits to Hungary and Poland. You take an issue which is a feature, for instance, that you have in Germany and Austria, you have theoretically an influence of the Minister of Justice on individual criminal proceedings. Maria Berger has been in this position. I guess she never used this instrument when she was a minister, and all the ministers before and after her refrained from doing it. But if we go to Poland and then we get the example of Austria or Germany. In Germany, you have to think of, you have 16 ministers of justice. They could never influence in a systematic way, and even naming judges, electing judges would not work in a federal state like Germany. You could not like in Poland, change the judges against the background of a political party, because you have, let me guess, six or seven different political coalitions in the various Länders, Bundesländer in Germany. So again, you have a federal state with 16 judges, ministers of justice. So the situation is so specific in every member state. So I think the Commission is very well aware, you need a holistic approach while looking at individual results. And therefore, I'm not in the position to say, well, I would have given, instead of a yellow light, a green light or a red light. This is not the kind of how a judge looks at things like this. Therefore, I think we have good results here. We should start a dialogue on this, and perhaps if it comes up to recommendations, one should always have, and I think the Commission has in its starting points, makes a caveat that, of course, it's not 100% clear-cut criterion, but it is a clear recommendation how to improve rule of law on the whole, and therefore I'm basically positive on this process if one is aware that we need this holistic approach when we deal with the rule of law.
May I ask you something specific on a point you mentioned earlier, which is not so much you as the president of the Constitutional Court, but as a legal scholar, which is when you even used Rechtsstaatlichkeit and rule of law and the French tradition, do they really mean the same thing in all countries? So even there, I think you have so many differences in the way that they have been understood. The term itself, historically, the way it's evolved, how courts have interpreted it in these three countries. So do you think one of the problems is the lack of a common understanding in the 27 countries?
I think this argument is used by some, but admittedly, there are differences, but what we have is a core understanding of core principles. And you can say that, of course, the history of judicial review in France in the 19th century was different from that in Prussia, in Germany in the 19th century. But we have a common understanding what is an independent judge. And we have 60 years of case law by the European Court of Human Rights, how a judge loses its independence if he or she may be removed from her office, or if the term of office is not long enough. So although we have a heritage which stems from various national systems, we now have a common understanding of the core elements of rule of law, like independence, speedy proceedings, impartiality, public hearings, and so on. Therefore, I think we can, and the Commission does in all its documents, base its actions on a firm European basis, which has, Commissioner Reynders mentioned it, which has to a large extent been developed by the court in Luxembourg, the court in Strasbourg, and also the constitutional courts in the member states.
Dr. Berger, anything to add from your own experience? Because Professor Grabenwarter just referred to it as Justice Minister, the question of just refraining from any influence on courts. And this is something which we are not seeing everywhere in the EU.
Yeah, thank you very much for this question. What I like about the report, of course, is that it confirms that in the Austrian public, the independence of the Austrian judicial system is a very good one. Yeah? So that we are amongst the 3 or 4 best placed member states, the judicial system as a whole. Of course, there always have been concerns about the lack of independence of the prosecution system. And already as a former minister or as a minister of justice, I was in favor of separating the role of being the highest in the hierarchy of prosecution and the role of a minister of justice. I was always in favor of putting an independent personal institution at top of the prosecution system, and it's positively noted that they are now at least, we have discussions, and I hope this government will really table a reform bill in this question. But what I also like in the report is, of course, that when it comes to media pluralism and the fight against corruption, I find some sentences in the report very, very timely, and we will see what next year will be written in this report. But I want to cite 2 sentences. Investigations into high-level political corruption have intensified following recent political scandals. However, prosecutors working on these cases have faced negative narratives from politicians. I think, and I expect that this sentence will be also we will find also in the next report. And media continue to receive high amounts of state advertising advertising spending, but concerns persist as regards the fairness and transparency of their allocation, potential political influence in the process, and insufficient reflection of media pluralism considerations. I think that we're very foresighted persons who have written this sentence into the report. But what's really the next thing to do in Austria is certainly to strengthen the independence of the prosecution system. And if I may continue, because you put also the question concerning the EU system as such, no? Even if it's not, so to say, subject of these national reports, of course. But what really I think becomes a big problem is the fact that we've seen that the judicial national system do not really function very well in some member states, and I'm particularly now talking about Greece. Yeah? So we were with some other lawyers in contact with lawyers in Greece, for instance. The people living at these islands, yeah, and clearly under conditions which are clearly incompatible with all EU standards and laws, yeah, that the Greek national courts do not accept any lawsuits. So you can't go to a Greek court to say, please give me the rights, yeah, which EU law, yeah, provides. So, and I think in this kind of situation, I think it's a high responsibility for the Commission to step in with infringement procedures, because sometimes you can wait. Yeah? You can say, okay, there will be complaints at the national courts, no? And somehow these complaints will go up to the European Court of Justice. But when the national system is a complete failure, then I think it's an even higher responsibility for these general instruments like the infringement procedure. And a similar situation is with all the pushbacks, because all the people who have been pushed back from the EU borders, they are not going in Turkey or in Libya to look for a lawyer, and to file a lawsuit against, I don't know, the Greek, Croatian, Polish authorities who pushed them back with the help, as we have doubts now with Frontex. So I think here, I know that the Commission is very active now as concerns Frontex, but I think they are also the general instruments at the disposal of the Commission should be used more often, and more targeted.
Would you like to react directly to that, Commissioner Reynders?
But we have tried to engage a lot of infringement proceedings in different ways if you look to the last years. Because first of all, I want to say that it's quite recent to have such a huge debate about the rule of law and the values at the EU level. Why? Before, we have had many discussions about the economic convergence, the budgetary situation. We have reinforced that due to the bank crisis, the sovereign debt crisis, and now we have country-specific recommendations in the European semester about all those possible reforms in different ways, also about the justice system. But since maybe 5-6 years, we have seen an increasing in the discussions, not only in the Commission, but also in the Parliament, and certainly in the Court of Justice, with new rulings. Of course, there are rulings since some times, but if you look to Strasbourg and Luxembourg, we have more and more rulings about those issues. I mean that it's true that there is a crisis. If we are doing that, it's maybe due to the fact that we have seen that it's not sure that we will stay with the same application of the same values in all the member states. It's possible to see some changes, and we need to take care of this. So that's the first element. So it's very recent, and we have introduced, I said, new tools to react to that. The second element, we have a common approach about the standards. What are the definitions of the different elements of the rule of law in the different chapters that we have put forward. But again, we don't want to have exactly the same system in all the member states. You mentioned the different historical process, different culture. What we ask is to be full compliance with the standards. But of course, we have different, I said, electoral system in all the member states. We have different organization of the justice system, and it's possible to stay with that if, at the end, it's possible to say that we are in full compliance with the standards. And then, when I'm looking to the situation, again, in many member states, we ask to improve the situation, to make progress, and in others, unfortunately, we have a more deep concern because there is a systemic issue. It's not by coincidence that I said that we have introduced the previous Commission an Article 7 procedure about Poland. We are in the Court of Justice with infringement proceedings, and now I've proposed to the Commission to ask financial sanctions on Poland due to a lack of application of the last decision of the court. So we increase the situation. But again, to go back, it's maybe my role, to the situation also in Austria, because you said it. Of course, we have said, and I discussed today, it's possible to improve the situation. Because we have horizontal discussions in Europe. Just two examples, maybe. The first one, the independence of the prosecutor office. I've discussed that with all the ministers of justice at the EU level in the Justice Council. And it's not to say that it's a failure in Austria or in other countries, but it's possible to improve. Why? Because we are sure that for the moment there are too much links between the executive branch and the prosecutor office, and it's very important to try to work on it. I know that there's a working group of experts in Austria. We will see what kind of proposal will come out of such a group. But then it's needed to have a political debate. And it's true that the rule of law report is helping to force such a debate and maybe to make progresses like in other member states. In a country like Luxembourg, there is a constitutional change to put in the constitution the independence of the prosecutor office. The other issue is the independence of all the judges. But when we are speaking on the independence, we are speaking about the appointment. And again, in Austria, just to say, there are some participation of the judges in the way to appoint different other judges. But if I'm looking to the president and the vice president of the Supreme Court, or to the president of the administrative court, there is no involvement of the justice system in the process. And I know that there are also discussions to see how it's possible, or to work with a panel, like we have seen with other appointment, a panel with judges involved in that. But in many member states, we are in discussion about the Judiciary Council or the Council for the Judiciary. There are different names. With what kind of standard? We ask to the member state to put into place or to reform the Judiciary Council, to have inside the council a majority of the members that they are judges elected by their peers, and so to give a real independence in the process. But it's not to say that there is a real problem of independence in Austria. It's just to say that it's possible to improve and to go further in that. And it's true that if it's possible to go in such a direction, we'll have also to think about the accountability of all those independent judges or prosecutors, because if we are pushing for the independence, we also need to exchange on inside the judiciary the possibilities to organize a good process about accountability, but not in the way that we have seen in Poland with disciplinary proceedings against judges or lifting of immunity in the last days or last weeks, also due to the fact that one judge was applying a ruling of the ECJ. So it's quite impossible to us to agree that you have a disciplinary procedure to do that. So again, it's very important to take into account the global context in each and every one member state to understand the situation. And so again, in some, and it's the case in Austria, we are asking for improvement. In others, sometimes we have a huge problem, and we are sure that we need to use other instruments than the dialogue in the rule of law report. And I was very pleased to listen to the two sentences that it was possible to put in the report about Austria. But it's true that we have listened also in Austria some comments from the President of the Republic or from some member of the judiciary about those attacks from politicians against the judges. And so it's quite important to say that there is a risk there, and we need to take into account such a kind of risk. And we will continue to put that. And about the media, of course, it was during the pandemic a huge problem, but also out of the pandemic, to see state advertising without a real transparency in the way to organize, not only here, in some member states,
in many member
and without a fair process to guarantee the media pluralism. And so we are just asking to organize a real transparency about the state advertising, it's the money of the taxpayers, and not only transparency, but a fair process to promote the media pluralism. I'm not saying that there is no media pluralism in the country. It's just to say that it's possible to improve and to avoid such a deviation, because it's not only one member state, it's in different member states that we have seen that. But again, I'm very pleased to listen from the President of the Constitutional Court that the report, you need to see the report as a real tool to engage a dialogue and to provoke discussions about reforms to go in a better way in some member states. But if you don't have such a dialogue, we need to use other tools. And of course, when you look to the last decisions maybe in a country like Poland, we need to use all the tools at our disposal, because there is a real conflict. And sometimes, of course, if we have a real conflict, we need to use other instruments, that a dialogue instrument like the rule of law report.
Mm-hmm. Would you like to come back on something?
No, I think that was a fine conclusion already.
Then
I see that you have quite a number of questions.
Yes, I have several questions. That's why I just wanted to, before I move on, because I was going to move on to a totally different question. This comes from Ulrike Hassmann-Vorbach. She's at the Austrian Federal Economic Chamber. And she has a question on something we haven't addressed so far at all. So I'm just going to read out the question to you as written. There is an increasing tendency towards protectionism and discriminatory measures against foreign investors in some member states. The European Commission's rule of law mechanism, in particular the annual report on the rule of law, has so far examined compliance with the rule of law in only 4 areas. But reliable rule of law structures in economic life and rule of law behavior by public authorities are key prerequisites for investment and trade. Non-compliance and circumvention of European regulations leads to enormous distortions of competition for companies operating in the internal market. So the economic dimension, and that is what she would like to stress, should be given much greater consideration in the rule of law mechanism, or a separate economic chapter in the 2022 rule of law report.
Two elements of answer about that. Of course, we have other instruments again and other tools to guarantee a correct application of the competition in the union. But if you look to the report, the independence, the quality and effectiveness of the justice system is one of the best tools to guarantee a good functioning of the internal market. Because to be very concrete, an Austrian judge, but also a Polish judge, is a European one. And with the report, we are asking for a common application of the EU law in the entire European Union. And that's very important to protect investors, to protect the business. So it's not just a protection for the citizens, of course it's important, it's also a protection for the businesses. And so the first chapter about independence, quality and effectiveness, so to don't have very long procedure in justice, to have a real efficiency, it's very important to have a correct functioning of the internal market and a protection of the investors. And of course, the second chapter, the fight against corruption, with a relation with the effectiveness and quality and independence of the justice system, it's also a protection. So it's true that there is no chapter dedicated separately, but if you read the report, you will see in many places reference to a correct functioning of the internal market, because the rule of law is also for that. And we try to explain that when we are fighting for an independent justice system and that we are fighting with correct resources to fight against corruption, it's a real protection for the businesses and the investors in the entire European Union.
There is one very particular question on Poland. This is a PhD candidate who is in desperation, who is writing about the backsliding of the rule of law in the European Union and poses the question. The person hasn't written their name, so I'm just reading out the question anonymously. What can you really do if a member state like Poland states that certain parts of EU treaties are not in conformity with the Polish constitution, when only one day before that the ECJ highlighted the importance of the primacy of EU law in a case that it ruled on? I'm running out of ideas, because who else can be followed if not the European Court of Justice? Maybe others as well would like to ask that, then I come back to you.
Yes, I think the European Court of Justice does important work, and it has already done important work, but it needs support by the Commission. It needs support also by other courts, other constitutional courts, other Supreme Courts, because as Commissioner Reynders has said, every national judge is a European judge. And I can just say what has gone on among Supreme Court judges, Constitutional Court justice during the last years. We are aware that we need mutual trust. If we don't have mutual trust, a community of law cannot work. And therefore, every ruling of the European Court of Justice in this aspect, of course, we have academic discussions on whether Article 19 serves as a valuable basis. And I think the European Court of Justice is not saying we are the only one who can save Europe. But in Luxembourg, people and the judges and colleagues are very well aware that it's a common issue for all European judges to keep this system going. And Commissioner Reynders has mentioned to the fact it's not only businesses, it's the particular individual person, not only as a consumer, but as a person, not only citizen, as a person living in Europe.
Like me. I'm not a citizen living here.
Human rights do not refer to citizenship. And our complex world is now that Europe has a high standard. It has worked on it since 1945. It has worked hardly, and and we have to keep this. We have to go on to keep this heritage. We as people living and working in the beginning of the 21st century, we build our bricks on top of what has been reached over decades in the 20th century. So all courts, all judges have worked together, also in bilateral contacts. The Conference of European Constitutional Courts in February explicitly addressed the situation in Poland in a rule of law statement, really, because we are aware if there are a higher number of constitutional courts or justice systems which fall apart, the whole system falls apart. So this awareness, and I think we had a number of conversations on the issue. I think we fully agree that it's a common issue, and if the court in Luxembourg is split apart from some constitutional courts, we will not be successful in addressing this crisis.
Mm-hmm. Can I formulate the question in an even larger context? This is the next person who's sent us a question for all of you, and it says, and may I start with you, Dr. Berger, in your opinion, what could the Slovenian EU presidency do to address the situation, both in Poland, which we've been discussing quite a bit, but also in Hungary, which we've forgotten a little bit about?
Okay, maybe I come back to the
You'd like to address
second question.
Yep. Mm-hmm.
And I think I want to underline what Mr. Grabenwarter said, that the task for all Supreme Courts and constitutional courts in Europe. And as a reaction to this Polish judgment, okay, there are voices saying that's not a judgment at all, and the judgment by itself is unconstitutional according to the standards of the national constitution, because there's no reasoning at all, and so on. But that doesn't really help us a lot. But I wonder whether the Commission could say go a little bit stricter against Poland, because now this week are the oral hearings at the Court of Justice, no? As regards the validity of the conditionality mechanism, and the Commission suspended its application, yeah? At least for one of the funds, as far as understood. Maybe this suspension can be lifted, and I expect that there will be an infringement procedure against Poland, as there is an infringement procedure against Germany because of one judgment of the German Constitutional Court, which addresses the same question but doesn't by far, not going that far. Yeah. But it's. There are also lawyers saying that what the Constitutional Court said is already, so to say, the motion for the Pole exit. Yeah? But I think one can say this: it's Article 50 of the treaty. Yeah? Requires a declaration of the government according to their constitutional rules, and that's certainly not yet the case.
Maybe just about the question on Slovenia first. It's possible, of course, for Slovenia to continue the work on the rule of law during the presidency, and it will be the case. So we will have a general debate on the rule of law report. We'll have a debate on 5 member states, so it's fine. And it's possible to continue the discussion about the Article 7 on Hungary and Poland. So for a presidency, it's quite huge to do that in the Geneva Council. And I've asked us to continue to engage on horizontal issues with the Justice Council, and maybe to discuss in other formations of the Council. But I will to go back to the general question on this, and certainly about the situation in Poland in the last days or weeks. First of all, I agree with the President of the Constitutional Court that it's a need to work together. So it's not just the job, I will say something about that, of the Commission or the Parliament or the Council or the courts in Luxembourg and Strasbourg, also the National Supreme Court and Constitutional Court. We need to work together and to show that we are sure that it's needed to have a correct application of some principles, just 2, the primacy of the EU law, not only on the national laws, also on the constitutional provisions. Because it was agreed by the member states in the treaties, and in Poland, to be concrete, by referendum, to take part in the process, to have an accession, and to have a full respect for the primacy of the EU law. And the second element, the binding character of all the decisions, the rulings of the European Court of Justice. That means not only for national authorities in general, also for the courts, and also for the constitutional or Supreme Courts in all the member states. But having said that, first of all, again, I try to explain sometimes that we need to continue the dialogue between the member states. I'm very pleased that there's a real dialogue between the Supreme Court and the Constitutional Court in Europe with the European Court in Luxembourg and the Court in Strasbourg, because it's very important to exchange on it, and we will try to improve again that. But at the Commission level, of course we are reacting, because we don't want to have such a spillover effect with different kinds of member states or different kind of institutions challenging those principles. So it's the reason why we are, since some time now, with a real debate with Poland about all those reforms concerning the judiciary first. And I've said sometimes it's possible to disagree with the Commission. I fully understand that. It's normal that one member state is not on the same line as the Commission. But when there is a decision, a ruling of the Court of Justice, it's binding. It's the end of the game. And so there is the reason why we have asked financial sanctions. And now, when there is a challenging about not only the EU law, but the treaties, because if you read what we are knowing till now from this last decision of Constitutional Tribunal, it's a real challenge about the primacy of the treaties on the national constitutional provisions. And that is unacceptable. So I've said we will use all the tools at our disposal. We have full confidence in the ECJ, but we have said that. We have a toolbox. And of course, just 2 last remarks. The first one, we don't have, I said that many times, don't have the same timeline than Twitter. So for the Commission, it's impossible to react in 1 hour about the decision and to ask the Court of Justice to do the same in 1 hour. We are respecting the rule of law, so we are organizing a robust dossier to do that and to be sure that it's possible to react. But like you said, it's very important to show that we are doing that on an equal footing with all the member states. But it's the first time that the decision concerned the treaty and not the secondary laws or the different laws at the European level. But when we have seen a real challenge to the primacy of the euro, we have reacted about a decision in Germany 1 year ago. But there are other cases when it will be needed to react. But at the end of that, I'm also very pleased to see that we have the opportunity to go to the member state. And I will go to Warsaw, like to Budapest, like I've had a visit to Vienna, because I have seen also the reactions in the country. And at the end, that's the culture of the rule of law, to be sure that it's not just imposed by the European institutions, but it's agreed by the member states and by the citizens. And again, I want to be very clear, we don't impose any rule on the member states. It was an agreement of the member state to share the same values, to apply the same treaty. It was a decision in Poland to do that. It was not an imposition coming from Brussels, to be concrete. And that's maybe important to repeat and to explain. And in such a debate, what is also important is to show what's the importance of rule of law in the daily life of the citizens. Because sometimes it seems to be abstract when we speak about independence of the justice system or independence of the prosecutor office. But if you have a problem with another citizen, with the businesses, or with the state, you need to be sure it's possible to go to an independent, qualified, and effective judge. Without that, it's a nonsense to go to justice. And so that is very important in the daily life of all, not only the businesses, but the citizens and all the people, it was said, living in Europe, because we don't make a difference between the people living on our territory.
No, I take your point about the fact that it needs really to be underlined that there was a voluntary sharing of sovereignty.
Of course.
It is not an imposition. I take your point. However, what does surprise me is the fact that although, for example, to come back to the Hungarian government, the Lex EU, as we call it, the one which really did make it impossible for the Central European University to operate under these conditions of legal uncertainty in Hungary, it was found to be in violation both of the WTO and of the European rules, right, by the ACJ. Now, as you very rightly say, the decision of the court is binding. What we have seen, however, is not only that it's not been considered binding, but what we have seen is that the revised law is actually even worse than the original. And the question is, the Commission has so far not done much about it. And that's what makes it sort of, for those who are watching the reactions, wonder how seriously one needs to take these infringements.
Yes, but we have taken a lot of initiative on infringement proceedings. And again, when it's needed, we are going back to the court. When there are some risk for individuals, we ask interim measures. If it's not applied, we ask now financial sanctions. So, but again, we try to see if it's possible to have a dialogue on some issues, and sometimes to see if it's needed to go to a more active role with an infringement proceeding. But I must say that when I'm looking to the last less than 2 years, the beginning of this mandate, we have introduced a lot of infringement proceedings, and we have pushed pressure not only with the normal procedure, but with the request to have no financial sanctions. Of course, if it's not enough, again, we have asked to the Council to introduce other tools, and we have now a broader toolbox. But I know that there are many requests to do more and more to the Court of Justice, but it was said by the President of the Constitutional Court, it's not the only one way. If we are just waiting for a decision of the Court of Justice, it will be not sufficient, and we need to use different other tools. But it's true that when we have a decision, and there's a new law, we need to analyze the new law and to see if it's not needed to go back to the court again and again and again. But if it's that...
Decisions take very long. It took 4 years for this decision.
Yes, it's true that we need also to have a full respect ourselves for the rule of law. And just to give an example, when we are saying we will introduce a procedure, we are sending a letter of formal notice we are given normally 2 months for the member state to respond. If it's not satisfactory, we introduce a real action in the Court of Justice. But there, and it's the same in the other court, that takes some time to have the exchange of memories with the other party, because we have full respect for the rule of law. It's maybe not the same situation on the other part. And sometimes it's 2 years later, in July, we have received a decision of the Court of Justice about the disciplinary regime of the judges in Poland, and the infringement proceeding was introduced by the previous commission. But in justice, it's quite logical that that takes some time before to have a decision. It's not only about the university, about the NGOs. We have introduced the same infringement, but we have received a positive answer from the court. So we have asked to Hungary to change the law. With some hesitation, I have said we will introduce a request for financial sanctions. We are not moving, and they have moved. And now we are analyzing the new law to see if it's in full compliance with the binding decision of the Court of Justice or not. But I know, I said, is the reason why I make the comparison with Twitter. I know that there's some expectation to go very fast. But when we have concerns about the situation in one member state, we need first to engage a procedure with the member state, if it's needed to go to the court. And it's true that that takes some time before to have a decision. But I'm sure that now we are at the end of the journey with a situation like the situation in Poland. And it's the reason why we have asked for financial sanctions. And I said we will use all the tools at our disposal to reaffirm the two principles, the primacy of the EU law and the binding character of the ECJ rulings.
So let me come in the last and final round, which is when I would like to give each one of you a chance to make a final statement, and that is to think about what are the next steps which need to be taken based on the report. So one obvious question would be, are there things we can think of which would strengthen the impact of the report? What should be the way forward, in your view?
Well, it's a difficult question, and I think it's difficult to answer in a short time. I think one thought could be that, as Commissioner Reynders has said, justice is not working quickly like a Twitter message, but justice is working thoroughly, and justice at a European level needs effective justice in every member state. So we have to be aware that a court which is responsible for the uniform application of European Union law needs the help of thousands of national judges who are, as you said in your initial statement, who are European judges. National courts have other tools in implementing their judgments. Mm-hmm. The execution of judgments is much nearer to the situation of everyone who seeks judicial protection before a national judge. And I think this idea of strengthening the independence and the effectiveness is really at the heart of this report. I can see that, and therefore I'm not giving advice because the Commission is very well aware of this, that this has to be accompanied by public debate and also education. You need education in schools, at universities, even beyond lawyers who work with it on a daily basis. But you need a common understanding that living in peace, like we do, fortunately, in most of Europe during the last decades, needs effective justice and rule of law as an answer to what we have seen in the dark parts of the 20th century. And I think if this awareness is there, if this can be communicated clearly, every action by the European Commission and all national authorities we'll have a firmer basis in order to come to that. Of course, this is future music, but I think we have to keep this goal in mind if we work today in difficult times.
So thank you very much. Let me turn to you, Dr. Berger, and then I'll give you final word, Commissioner Reynders. The question would be here, given also, as we just discussed, the temporality, that it just takes long, and it does take long. Do you think, given that, one would need different kinds of alert mechanisms or some kind of rapid response mechanism which would be necessary so that one can act more quickly also in the sense of prevention, because a report can also take long.
Yeah, and it also would take long to introduce such kind of new mechanisms, because sometimes they require a revision of the treaty or legislative procedures, which also take a long time. So I think it has been a good idea that the toolbox which we had already in place is better used now, and this is this kind of interim measures, which the Commission can ask for, and the court hasn't applied this instrument many times before, but now it's a very common tool in the meantime, and you can also put financial sanctions. You can add financial sanctions if the interim measure is not followed by a member state, and I think this helps already, and of course all the other tools, in particular the regulation and the conditionality, I think will certainly help, and I also would like to join Mr. Grabenwarter in this view that the awareness for the importance of the rule of law is probably very, very weak, and it's very easy for politicians to discredit this principle, because people do not really care. They think it's something for lawyers only, and I think we have to overcome this border and to explain that's the basics of democracy. And it's the protection of your rights, and not only some kind of hobby for constitutional or other experts.
So, Commissioner, two very quick questions on this. The same one to you. How do you think we as citizens, and I say this as a non-EU citizen, but someone who's been living for 40 years in different countries in Europe, so what could we as citizens do to strengthen the impact of this report on the one hand? This is a question we've been discussing at the moment. And the second is to come back to a point which you made, which I thought is important, which is to say how to link the new mechanisms to other policies, other frameworks within the EU. So you mentioned the Justice Scoreboard, you mentioned the European Democracy Action Plan. Do you think that would be one way forward to strengthen the impact of the report as a tool?
Of course, but there are two things. First of all, to answer to your questions, it's very important to continue to work with such a report to build or to reinforce a real culture of the rule of law. And for the citizens, it's very important to take part in discussions, in debates, also at the national level, to continue to build such a kind of culture. And I fully agree on the fact that we need also to discuss about the educational process, how it's possible to have such a kind of discussion, to explain what that means, the rule of law in the daily life of all the citizens. I'm sure that for the young generation, it's very important to be educated on this, because when you look to the reaction of the young generation about the climate change, with so many demonstrations, it must be possible to show that there is a link with all those requests and the rule of law. And you spoke about the protection of individual rights, fundamental rights for minorities and so on. Without a real culture of the rule of law, you don't have a protection for asylum seekers before a constitutional court or a constitutional tribunal. You don't have a protection for the minorities. You don't have the capacity to do that. So we need to extend that. But the second element is more and more important to do that, because if we don't do that at home in Europe, we don't have the capacity to be credible outside. And when we are looking to the situation in the rest of the world, it's very important to be sure that we are going to different international discussions with a real job done at home to be credible and to try to say that we have some things to do and to say about different situations concerning the rule of law, the human rights, or the democracy in other parts of the world. But again, the culture is the most important element. How it's possible at the national level to go to universities like you are doing, but to go to schools, to go to all the places to work on it. And I'm very pleased to say that due to maybe the supporters of the European Parliament, now we have an increasing budget to fund different action from the civil society. It's 1.5 billion in the new programs that we have. And that will be very important to put into place different kind of actions in all the member states, because that's the main goal, is to have a real culture. If we have a culture of the rule of law, it will be quite impossible to continue some kind of action that we have discussed today in different kind of member states against the independence of the judiciary or other issues. But it's not easy, because it's the task also from the citizens, from the civil society, to explain what that means in the daily life of all the European people or people living in Europe when we are speaking about all those maybe sometimes abstract concepts like the rule of law or other kind of issues. So both continue to install the culture in the European Union, and on such a basis we have the opportunity to discuss with like-minded countries about maybe the implementation of the same kind of standards in the rest of the world.
Thank you very much. Thank you very much for joining us today online. It's been a great pleasure to have all three of you attending this evening's discussion of the report. I hope that it will give the report much greater visibility, dissemination, and therefore a little step towards inculcating a culture of respect for a rule of law, which is such an abstract principle, but I think we've managed to decline it down to some very concrete examples. And thank you very, very much once again for being here today with us and for the very productive discussion.
Thank you.